Next case on the docket is WACZEWSKI versus Westgate Vacation Villas.
Just my guess. May it please the Court, James WACZEWSKI with Lux Antoniello on behalf of the appellants, Jose and Susan WACZEWSKI. I'm here today, obviously, on an appeal from a final summary judgment that was entered by the trial court in this personal injury action. The order on summary judgment did not express any reasoning, it was just granting a summary judgment. And shortly thereafter, there was a final summary judgment that was entered, and this appeal ensued. Going back on the background a little bit, the underlying lawsuit arose from an accident that happened in 1997 in which Mrs. WACZEWSKI was injured. She suffered a broken coccyx, and she continued working for some time while she was getting treated. She tried to file a workers' compensation claim, was intimidated while she was trying to do so. Eventually it was accepted, and about a year after she filed it, and certain things happened, and about the same time that she found out that the injury was permanent and that she was going to have to live with all this pain, she was fired from her job.
If you were ultimately successful in this lawsuit and in fact recovered monies, would they go to your clients or would they go to their creditors who were discharged in bankruptcy?
Well, the creditors were not discharged in bankruptcy as to Mrs. WACZEWSKI. So as to Mrs. WACZEWSKI, it would go to her because she was able to convert to Chapter 13, and she basically did a reorganization plan, and she paid her creditors herself.
In full?
Well, not in full, it's just according to the plan.
Okay, so the creditors who were shortchanged because of the Chapter 13 would not get any of this money if she succeeds in this action because she was able to get that reduced in bankruptcy?
No, not exactly. She's still, I think that her bankruptcy case is still ongoing, so they wouldn't be shortchanged. I mean, she would notify the bankruptcy court, and then they would arrange if there is any change in the distribution.
Isn't that an indication as to why this whole dispute is within the bankruptcy case and shouldn't be here in state court at all?
It has really nothing to do with that, Your Honor. Obviously...
Well, I mean, aren't the proceeds from the settlement part of the bankruptcy estate? Isn't that an asset of the bankruptcy estate?
They are part of the Chapter 13 bankruptcy estate, yes.
Right. So doesn't the trustee kind of have the control of whether or not to settle the case or not?
Yeah, well, obviously, initially there was a Chapter 7 trustee as to Mrs. WACZEWSKI. And when he took over as the trustee on the case, he did have the authority to settle the case. I was appointed special counsel, and I represented the estates of Mr. and Mrs. WACZEWSKI in bankruptcy court in the prosecution of the personal injury / wrongful termination action in state court. I prosecuted the action, and in the end, obviously, the management of the case was done through the trustee. The trustee had the right to make decisions about settlement. But what happened here, it wasn't a regular settlement. There was some misconduct involved in it, and that's what we allege in the reply to the answer that they filed
What
subsequently.
was the misconduct that you alleged?
Well, the misconduct, it goes in many ways. Well, first of all, when Mrs. WACZEWSKI and Mr. WACZEWSKI were in bankruptcy, and I was prosecuting the action, during the prosecution of the action, all of the defendants, or 3 defendants, filed jointly, well, not jointly, separate proposals for settlement for a total of $20,000. In consultation with the trustee,
Aren't these all issues that were raised in the federal court?
well, no.
In the context of the objections to the settlement and in the context of the appeal to the 11th Circuit, didn't they already address these issues?
No, they did not. We actually reserved the issue of the misconduct for the state court. The only thing that was raised,
Sorry, I didn't hear what you said.
we reserved, as a litigation strategy, we did raise several arguments that I can easily explain to the court what were the issues in federal court. The one thing that we didn't want to do before the bankruptcy judge is to say that there was some kind of misconduct by the trustee, because we didn't feel that the judge who deals with the trustee every single day would have, would listen carefully and maybe consider the evidence that we have in this regard. The fact is that what we raised in federal court, the only minor issue that would raise us to any misconduct was, yes, when the bankruptcy judge had the authority to decide, am I going to accept the defendant's proposal here that they've submitted to the court to settle the remaining part of the case for $10,800? Am I going to accept that as a compromise and resolve this case, or am I going to accept Mr. WACZEWSKI's offer themselves to the bankruptcy court that we will buy out the lawsuit, we'll pay $11,300, it's $500.
But you also raised the issue of whether the one co-defendant could hold up payment and condition the actual payment on the acceptance of the offer by the other co-defendant. Didn't you raise that? I mean, the 11th Circuit talked about that.
No, that's what I'm getting at. What I'm getting at is that when the judge was considering both offers, what we did argue is this, is that if there is some misconduct on the part of the defendants who made this offer, that the bankruptcy court should take that into consideration in deciding which offer to accept. And what happened is that the bankruptcy court accepted the defendant's offer together with the trustee, where there was a direct payment of the $10,800 instead of taking the monthly payments from the WACZEWSKIs. And what the 11th Circuit said is, well, yes, the evidence does show that the defendants, basically withheld this money that was accepted, did not want to pay the first settlement of $9,200 until they convinced the trustee to accept all of the offers. So there is evidence to support that, but we don't think that that was an abuse of discretion by the bankruptcy court to instill in deciding what's in the best interest of the creditors to accept the other offer.
But the claim that this is your parents, right? Your mom?
Yes.
Your mother had was an asset of the bankruptcy estate, right?
That's correct.
All right. So and the bankruptcy trustee compromised it, and the proceeds became a part of the bankruptcy estate, right?
Yes.
I'm at a loss to understand how your client still has the right to pursue that and pursue a double recovery on that claim.
I'll address those two questions. As to the first issue, let me put it this way. Let's say that, for example, and I'm not going to say that this happened exactly in this case, but let's say that, for example, while the defendants, through their counsel, and it wasn't Mr. DiMartino, by the way, while the defendants went and engaged in this ex parte communication with the trustee, let's say that they say, look, we're going to give you on the side $10,000. My client is really upset about how this proposal for settlement was set up. They don't want to pay the initial $9,200 that the all accepted, that the bankruptcy court approved. We just don't want to pay that. We want to get rid of this whole lawsuit. We don't want to pay $9,200 and still have a whole lawsuit ahead of us. So we'll give you $10,000 under the table, and you just go ahead and
give
propose.
the trustee some sort of bribe or something like that.
Let's say that's an example I'm trying to keep, okay?
You'd have a remedy if that were the case, right?
Then the remedy-
bankruptcy court, right?
it would be in either court, because it would be misconduct by officers of the court related to both actions. It would be misconduct in the bankruptcy court and also misconduct here in the state courts, because the proposal for settlements, the lawsuit was filed.
Well, what you're trying to do, so here the trustee got the money, kept the money, and used it for purposes of paying administrative expenses and creditors' claims. Now you want to sue these same defendants, in effect, a double recovery, right?
Well, no. First of all, the creditors did not receive a penny from that money. All of that money went to the
It may have gone to
trustee.
administrative expenses. The bankruptcy court controlled the disposition of that money, and now your client, outside of bankruptcy, wants to effect a double recovery.
There wouldn't be any double recovery. First of all, because even if, for example, the court accepts our reply, accepts the avoidance of the settlement, either the money will be returned to the defendants or it will be credited towards any judgment that would be subsequently entered for the plaintiffs. And any monies that go to Mr. WACZEWSKI would go through the bankruptcy state. Any money that goes through Mrs. WACZEWSKI will go through the separate Chapter 13 bankruptcy. There wouldn't be any double recovery.
I don't understand how that would happen. How would, just because you're saying that's the way it would work, is that, I mean, they're suing, that you're trying to bring a claim that really doesn't even belong to your clients anymore.
Well, it does belong. All the case law says this, that any time that you have a personal injury lawsuit and there is a potential excess recovery, and in the case of Mrs. WACZEWSKI, for example, she should have never filed for bankruptcy. Her debt was only about $20,000. So any time that there's a recovery over that, that's an interest of hers. That would go revert straight, to her. So she always
Wouldn't
has,
you have to get some, and I don't know much about bankruptcy, but wouldn't you have to get some sort of an order from the bankruptcy court, either releasing that claim from the bankruptcy estate or somehow indicating that it was hers to do with it as she chose to?
Well, no, not exactly. I know it is difficult and it involves a complex bankruptcy law, but I mean, when people convert to Chapter 13, basically they become what is called debtors in possession. So as to Mrs. WACZEWSKI, who is in Chapter 13, the money that was put in the estate, by the defendants on her estate would be part of her Chapter 13 estate, and the lawsuit was still in existence. This was not a situation where the Chapter 7 trustee, while he had an interest in the lawsuit, voluntarily dismissed it or did something like that, or tried to.
I guess the difficulty that I'm having, and this may be in part because I really don't understand bankruptcy to any great degree. If your contention is that the bankruptcy trustee didn't have the authority to settle the case because it had been converted to a Chapter 13, isn't that or for any other reason, for whatever reason, if the contention is that the trustee didn't have the authority to settle the case or that the settlement wasn't in the best interest of the bankruptcy estate, wouldn't that be a dispute that you would have to resolve with the bankruptcy court? Because we can't say sitting here whether it was a good settlement or a bad settlement. So I guess, I mean, I understand your argument. I just wondering if you're not knocking on the wrong door and that the door has to be in the bankruptcy court and the bankruptcy court has to say, go to it. We're going to release this case back to the state court and do whatever you want.
Yeah, but that's not at all what I'm arguing. I'm not trying to go back and say that the trustee at the time that he made an agreement with the defendants that he had no authority. I acknowledge that at that time he had the authority to settle. What I'm saying is that there was some misconduct involved in that transaction, and that because that is a defense, a settlement is a defense in Florida, under Florida law, that and the lawsuit is still existing, it's still pending even, well, not today, of course, it's now on appeal, but it was pending until
Well, but if there's litigational misconduct, aside from remedies such as, filing grievances and that sort of thing, I mean, a settlement is essentially a contract. If there's a breach of that contract, isn't the remedy, since the contract was entered into in the bankruptcy court, wouldn't the remedy be to set that aside and then set the settlement aside or pursue your other breach of contract remedies?
Well, wherever the settlement happened, it didn't happen in bankruptcy court. All that happens in bankruptcy court is that because there's a bankruptcy case pending, the bankruptcy court has to approve that settlement. It could have happened in state court, it could be in a judgment in state court, and then the bankruptcy would get some money out of it. All that the bankruptcy court has to do was say, okay, well, you guys decided to settle this, you have your release, you have your contract, whatever it was that you all entered into, let me see what the terms are. Okay, well, here's the motion for to approve the compromise. Here are the terms that I see in front of me. Well, that's in the best interest of the states because, you could go to trial and lose. That's all she has to do. She's just approving the settlement. The settlement is of a state lawsuit, an action that was filed in state court.
The trustee owns the lawsuit at that moment in time.
Owns it in part. He has the right to manage it. He has obviously the right to make the decisions.
He has the right to settle it.
Yes, and he does have the right to settle. But for example...
And the reason for the requirement of approval is so that the debtor has an opportunity to object to the value that the trustee has placed on it, so that the bankruptcy judge can determine whether it's a fair value, whether it's in the best interest of the bankruptcy estate. You went through all of that and you lost.
That's correct, yes. Obviously, not only the debtor, but also the creditors have a chance to object. Anybody who has any interest in the asset has a right to object. I would like to reserve 4 minutes. I still have a minute to go if y'all have any questions.
You only get that time, though, if he argues something.
Okay.
If he doesn't argue anything, you forfeit that time.
Well, I do want to clarify. I mean, I think that...
You can reserve the time. It's just that if he doesn't argue anything, you don't get to...
Okay, I'll reserve 4 minutes. But anyway, I want to clarify. I mean, I think that the law is clear in this case that, for them to be able to get a judgment below, they had to raise affirmative defense or settlement. They have never even established that there was a settlement. All they did is file a whole bunch of opinions. Okay? They didn't establish that. We also filed a reply, which properly makes allegations that would be sufficient to avoid the settlement. That issue wasn't even addressed in their motion for summary judgment, and the judge didn't even consider it. I think that we have, the plaintiff should be given the opportunity to go back to the trial court to depose the defendant's counsel who engaged in these ex parte negotiations with the defendants, and to then establish that there was misconduct. And the type of misconduct I'm talking about is not only the fact that you withheld money that you make proposals for settlements, we file an acceptance, they withhold the money, and then they go have ex parte communications with the trustee after the court already had approved, the bankruptcy court approved it, and say, hey, listen, we don't want to pay this money, you better take the rest or we're not paying it, And then whatever else happened, we would like to find out through deposing Mr. Dean Hewitt. I have 3 minutes and 30 seconds. I appreciate reserving that time. Thank you. Okay.
May it please the Court. My name is Guy DiMartino, and I represent the appellees in this matter. And Judge Thorpe, I appreciate the out of not arguing, but I feel that I do have something.
I wasn't giving you an out.
Oh, okay.
I was just trying to let him know, but I don't have any questions for you.
Thank you.
I really only have one question for you, and that is I want to confirm I didn't see in the file, you didn't file any motion for attorney's fees, 57105 or otherwise?
We didn't because of the situation, Your Honor.
That's all I wanted to ask.
Yes.
And I've got one question. I mean,
yes.
Essentially that, if I understand the position that he's arguing, it is that, there was a settlement made, but then misconduct in carrying that settlement out. And I guess what I'm trying to understand is that if, and I realize this is a little bit far-fetched, but let's assume that there's a state claim, debtor files for bankruptcy, so now the trustee has control of the claim, and the parties are at a mediation, and the debtor is there, and the defendant, in this case your client, punches the person out, commits a tort. Even though the case settles, who owns that claim? I guess if there's some misconduct or some separate tort that occurs, in the context, even though the case is in bankruptcy, who owns that claim?
I would think that at that point in time, you'd have a new claim that would be a separate tort. You said punched him out, right, Your Honor? So that would be a battery. At that point in time, that would be an intentional tort, and that would be if there's some type of claim, then the statute of limitations would run for that, and they can file that claim in state court. In this matter, this claim was settled on November 20th of the year 2002. The coercion, the third-party, ex-party contacts, all that information was brought to the bankruptcy court because in WACZEWSKI 1, the 11th Circuit says the trustee spoke to the attorneys, the trustee reviewed the files, the trustee met with independent counsel to determine the value of the case. That case was affirmed by the district court, went up to the 11th, and was brought back down on remand for an issue which had nothing to do with the settlement. And then a second round of appeals started. And then a third round of appeals started. This case was settled when Mrs. WACZEWSKI was a Chapter 7 debtor. At that point in time, Trustee Menninger was the proper party and real party in interest, and he settled this case. Sometime after, she became a Chapter 13 debtor after all that was out. But what the 11th Circuit said was, you're free to reorganize in Chapter 13, but your claim against the Westgate defendants has been extinguished. It was settled. It's the law of the case. And this is not the proper forum to collaterally attack these issues. I appreciate your time. Thank you.
Thank you.
Okay.
Well, first of all, I appreciate what Mr. DiMartino said, and I appreciate his kindness for not filing a 57105 because of my situation, I guess, because I'm the son of the plaintiffs. And I also would like to say that whatever Mr. DiMartino has said, both in the briefs and here, about what has been argued in bankruptcy court, comes out of his pen, his typewriter, and his mouth, because there's no record to show what was and wasn't argued. There are just some opinions.
When you moved for summary judgment below, did you file a counter affidavit?
I didn't have to. They didn't file any affidavits. All they filed was some opinions. So they didn't file, for example, the document.
Did you object to the lower court's consideration of the record from the bankruptcy court that was attached to the motion on the basis that it wasn't properly authenticated or anything like that?
It wasn't attached. The only thing that was attached was opinions from the district, from the bankruptcy court, the district court, the 11th Circuit.
Well,
but
the
11th
Circuit opinion said that the claim had been settled, that the claim belonged to the bankruptcy estate, and that the trial court's affirmation or approval of that was affirmed. Right? Yes,
and I'm not, and again, I'm not addressing that issue.
Pretty much establishes that there was a settlement of the claim, and then the onus would have been on you to attack that settlement on some basis through some sort of affidavit, right?
No, because there were pending affirmative defenses, and the standard in Florida is clear. Your Honor, I've been before this court maybe 6-7 times. I've been before the first DCA maybe 45 times.
That really doesn't help the argument.
I am not here just as some guy who's like representing his parents and never done law before. I work for an insurance defense law firm. I know what I'm doing, and I know what the standard for summary judgment is. And the standard for summary judgment is if there are affirmative defenses, it is his burden to disprove them. And then if there are affirmative defenses that he's relying on for summary judgment, and there is a reply, it would be the defendant's burden to overcome that before they obtain summary judgment. We filed a reply. We made allegations which are, that I will establish if I'll be able to depose Mr. Dean Hewitt, and if I have to file an affidavit later on, I will file an affidavit. But at that stage of the litigation, all they did was say there was a settlement. I don't dispute that there was a settlement with the trustee. I'm saying that there was misconduct involved around that settlement. And that issue is properly before the trial court in state court, as it could be done in the bankruptcy court. Just like, for example, very many times, people are plaintiffs, and I'm actually have a situation like this right now as a defense counsel. A plaintiff files a lawsuit against somebody, then goes separately, file for bankruptcy, and never discloses their personal injury lawsuit. Guess who the defendants go to get the case dismissed? They don't go to the bankruptcy court and say, hey, this debtor lied, she actually has a lawsuit against us, dismiss us. No, they go to the state court and say, the debtor lied about the state, about not having any assets in the bankruptcy court, so we got judicial estoppel, please dismiss us from the case. So the state court does have jurisdiction. I don't see why 57105 would apply in this case. I understand the PCA goes one way or the other, and sometimes I'm on the good side, sometimes on the bad side, but I appreciate your time.
All right, thank you.
Thank you.
Thank you, counsel. Court will take its morning break at this point.